Welcome viewers. The former guy's lawyers revealed his judge backed down. The ultramodern response filed with the aid of the former guy's attorneys in the unique grasp dispute before Judge Aileen Cannon smacks of an extremism and desperation possibly born of having been maneuvered into a felony nook via Attorney General Merrick Garland's Justice Department. Rather than presenting the dodges with a succinct appeal, Judge Cannon, in a cautiously tailored manner, requested that part of her personal disposition be left only sufficient to allow investigators access to categorized documents. The former guy's crime group begins with a rambling introduction that takes up nearly a quarter of its filing, in which it characterizes the full count simply as a dispute over record storage that unfairly criminalizes Trump's possession of his personal, presidential, and private records. Guy's former legal experts use quotation marks around the term classified, implying that the classification of files is questionable, claiming that only a clear understanding can restore order to chaos, and arguing that the Dodge is trying to break that system, to skip and go straight to a predetermined conclusion. It's all on the first page. The Dodge's decision to tone down its crime argument, to simply seek access to the flagged substances, is a smart pass because it satisfies the strongest phase of its argument. Namely that it is no longer possible to investigate a case with categorized files denying access to the documents, which leaves the ex-lawyer little propensity to attack the Dodge's choice to even review them. For example, their use of the phrase preordained conclusion clumsily attempts to mimic the cliched rush to judgment language famously used by legendary rogue protection attorney Johnnie Cochran in his profitable closing argument in O.J. Simpson's murder trial. But the conclusion that was difficult for Cochran was the conclusion reached by a crook investigation, which was that O.J. Simpson had committed murder. In contrast, the former lawyers try to manipulate the process of investigating crooks themselves. Kerfuffle over classification is another example of forced clumsiness. The phase of the former husband's lawyers is considered in their dismissive statement. The authorities have unilaterally decided that they will be classified as they are the categorized documents. This derisive statement rests on the stupid assumption that the authorities aren't allowed to decide what's secret and what's not. Their recommendation that judicial intervention is required to adjudicate these national security issues is a crucial reversal of the government department's powers and responsibilities. The best thing to say about Judge Aileen Cannon's decision Monday to appoint a special foreman to review documents seized from Trump's Mar-a-Lago resort is that it's not the end of the world. The Justice Department can continue its investigation into Donald Trump's alleged theft and custody of highly sensitive defense-related documents, at least those not seized in the August 6 search. The Washington Post reported that these documents contained nuclear secrets from other nations. It may also continue to examine his efforts to overthrow the presidential election that culminated in his role in the violent January 6 riot, taking into account a historic September 6 ruling by a New Mexico state court that the 14 mattered always to again hold public office in the United States.